Okay, I'm ready to get started. Good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf or offer evidence in your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you can remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be allowed, or you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You'll receive notice at the address you give of your next court date. Finally, could everyone raise their right hand for me, please? Do you swear or affirm any statements you make during this proceeding shall be the truth, the whole truth, so help you God?
Yes, sir.
Okay. Let's start with Mr. Garcia. We have Ms. Bermudez on. How are you doing, Ms. Bermudez?
I'm doing well, Judge. How are you?
I'm doing well. I apologize for the late notice, but you're right on time as always. Okay. Mr. Garcia, sir, can you hear and understand the interpreter?
Señor Garcia, señor, ¿puede usted escuchar y entender a la intérprete?
Escucho.
Repita.
No la escucho.
I'm able to hear her.
I'm sorry, what did he say?
That he's able to hear the interpreter.
Okay. Mr. Garcia, this is your first appearance before the Magistrate Court of Clayton County.
Señor Garcia, esta es su comparecencia inicial ante el Tribunal de Primera Instancia del Condado de Clayton.
My name is Brad Gardner, and I'm a judge in this court.
Mi nombre es Brad Garner y yo soy un juez en este tribunal.
I am not here to take a plea in your case or to have a trial of your case.
Yo no estoy acá para aceptar una declaración a cargos en su caso o para tener un juicio en su caso.
I'm here to notify you of the charges against you,
Estoy acá para informarle cuáles son los cargos en su contra,
to set future court dates,
para fijarle las cortes futuras,
to set a bond for your charges,
para fijarle una fianza en sus cargos
and to see if you require the assistance of an attorney.
y para ver si usted requiere la asistencia de un abogado.
It's important to note, Mr. Garcia, that this proceeding is being recorded.
Señor García, es importante saber que estos procedimientos están siendo grabados.
You have the right to remain silent and say nothing.
Derecho de permanecer en silencio y no decir nada.
But if you should say something, your statements could be used against you in the future.
Pero si usted dice algo, sus declaraciones podrían ser usadas en su contra en el futuro.
So please don't discuss the facts of your case.
O sea que por favor no hable de los detalles de su caso.
You have the right to the presumption of innocence,
Tiene el derecho a la presunción de inocencia,
the right to an accusation for these misdemeanor charges,
derecho a tener una acusación para estos delitos menores,
the right to a speedy and public trial by jury,
el derecho de tener un juicio sin demora, público y por jurado,
the right to see, hear, and question witnesses who are called to testify against you.
derecho de ver, escuchar y contrainterrogar a los testigos que sean citados a testificar en su contra.
You have the right to compel the attendance of witnesses to testify on your behalf.
Tiene el derecho de exigir la asistencia de testigos para que testifiquen a su favor.
You have the right to testify on your own behalf or offer evidence in your own defense.
Tiene el derecho de testificar a su favor o de presentar pruebas para ser usadas en su defensa.
You also have the right to have an attorney represent you.
También tiene el derecho de tener un abogado para que lo represente.
If you cannot afford an attorney, one can be appointed to represent you if you qualify.
Si usted no pudiera contratarse un abogado, uno le sería nombrado si usted califica.
Mr. Garcia, sir, you're charged with 4 driving-related offenses.
Señor García, a usted se le acusa de 4 infracciones de tránsito.
The first is driving a vehicle with no license.
Primero es de conducir un vehículo sin licencia de conducir.
Bond is going to be set at $1,000 for that offense.
Por ese delito, su fianza va a ser de $1,000.
You're also charged with 1 count of having an open container of alcohol in your vehicle.
A usted también se le acusa de un cargo de tener un envase alcohólico o de alcohol abierto en su vehículo.
Bond is going to be set at $500.
Esta va a ser de $500.
You're charged also with 1 count of improper lane change.
También se le acusa de un cargo de cambio inapropiado de carril.
Bond is also set at $500.
Esta va a ser también de $500.
And you're charged with 1 count of failure to maintain your lane of travel.
Y también se le acusa de un cargo de no poder mantener su carril en el cual usted estaba viajando.
That's also, bond is going to be set at $500.
La fianza también va a ser de $500.
Because these are all misdemeanor offenses, you're going to have a preliminary hearing date set for December 13th at 8:30 in the morning.
Por el hecho de que todos estos son delitos menores, usted va a tener una audiencia preliminar programada para el día 13 de diciembre a las 8:30 de la mañana.
That date will be waived upon your bonding out and you'll receive a new court date in the mail.
Esta fecha o esta corte se cancela tan pronto usted pague su fianza y salga, y usted recibiría un nuevo citatorio por correo.
Would you like for me to see if you qualify for the appointment of a lawyer?
¿Le gustaría a usted que yo vea si usted califica para nombrarle un abogado?
Are you currently working, Mr. Garcia?
Señor García, ¿actualmente está usted trabajando?
Sí.
Yes.
About how much do you make per hour?
Más o menos cuánto gana por hora.
¿Por hora?
Per hour?
Yes, sir.
Sí, señor.
35.
Me dijo 35 la hora.
Sí.
35 an hour.
And how often do you work?
¿Con qué frecuencia trabaja usted? ¿Con qué frecuencia trabaja usted?
En roof.
No le escuché.
En roof. En roofing.
En roofing.
Roofing. Okay. I'm going to find that you qualify, Mr. Garcia. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yo voy a encontrar que usted califica, señor García, y le voy a nombrar un abogado para que lo represente. ¿Tiene usted alguna pregunta para mí?
Creo que ahorita ya vino a pagar mi hermano la fianza.
I think my brother already came to
Ya pagó, creo.
my bond. That's what I think.
Okay. And these bonds are automatically set, sir. So it's possible that when you leave here, you'll receive notification that your bond has been made and they'll release you.
Y señor, estas fianzas son fijas automáticamente, o sea que existe la posibilidad de que cuando a usted se lo lleven de ahí, ya le notifiquen que ya la fianza ha sido pagada y lo pongan en libertad.
Okay.
Yes.
Okay, so you're free to go back.
Okay, señor, puede retirarse. Thank you.
Thank you, Miss Bermudez. We almost made it 5 days. We only got 4.
Yes, sir.
Have a
Yes,
good
sir.
day.
Thank you, and you have a good weekend.
You too.
Yes, yes.
Okay, let's pick back up on the ladies' side with Miss, is it Barthel? Barthel?
Be quiet.
Stand right there, look pretty, girl.
How you doing? They said a joke, it was funny. How you doing?
Stay in there. You trust-
I'm doing well, ma'am. And your last name is Barthel?
Barthel.
And how do you pronounce that?
Barthel.
Barthel. Okay. I believe everybody deserves the respect of having their name pronounced correctly.
I appreciate that.
You're welcome. Miss Barthel, ma'am, you're charged with 1 count of criminal trespass. This is a misdemeanor offense. Bond is going to be set at $3,000. There's going to be a stay away provision on this bond, to stay away from a Vanessa Barthel. Do you understand that?
Okay. Yes.
And I know it's a
We have a relationship like that. It's about that time. We're gonna get some counseling. It's about that time.
okay. Your preliminary hearing date, ma'am, is going to be set for December 13th at 8:30 in the morning. That
I'm sorry.
and this is for everybody's benefit. When I stop talking, the last thing I ask is, do you have any questions? And that's
Yes,
when
sir.
I shut up and then I listen. Okay. So you will be heard.
Okay.
So your preliminary hearing date is set for December 13th at 8:30 in the morning. That date will get waived upon your bonding out and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. I'm going to find that you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Now, I interrupted you.
Mhm.
Do you have any questions for me?
Yes. I actually have a court date in Tennessee on the 13th to 14th. But you said if I bond out, then it'll be a new.
Ain't gonna bother your fool.
It'll be a new.
I'm all right. I'm all right.
Hold on one second. Hold on one second.
Move back, Robin. Move back, Robin.
Okay. Deputy King.
Yes, sir.
Now, this is being recorded and broadcast on the internet. So it may be a little bit of discretion is needed.
Yeah, I'm about to handle that now, Your Honor.
Okay. All right. Can we unmute on the ladies' side?
Go ahead, Judge.
Okay. Thank you. So ma'am, if
Mhm.
you bond out,
Mhm.
that date is going to get waived and you don't have to worry about it. You'll receive notice in the mail.
Okay.
still in custody for that date, then you will have the hearing here, and somebody needs to notify the people in the other jurisdiction that you're in custody, and that's why you're not going to be able to appear. Okay?
Yes, sir. You're frozen.
I don't want to be.
Law library. That's a negative.
There we go. We're back. I need to thank you. So are there any more questions, ma'am?
Are you familiar with like how the bond works? Like if I don't have anyone and one person I do have is out of the state?
So the short answer to that, ma'am, is no. But the people there at the jail in the bonding unit, that's all they do.
Okay.
So if you have questions, they're the best source.
All right. I appreciate that.
Okay. All right, ma'am, you're free to go back.
All right.
Miss Garrett-Bates.
Yeah, come on here. 3,000.
I'm here.
They take, 3,000.
Yes, I'm here.
Miss Garrett-Bates, ma'am, you're charged with 1 count of criminal trespass. This is a misdemeanor offense, and it's basically saying that you were at a mental health institution and you have been told not to come back. So I'm going to set the bond at the lowest amount that I can, which is $1,000. You're going to have a preliminary hearing date set for December 13th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to appoint you a lawyer, ma'am?
I would like to see Steve Littles.
Okay, and that's with I believe he's still with okay. He's been your lawyer before?
Yes.
Okay. I'm gonna make a notation that Steve Littles is your lawyer. Lister and Holt is the name that I was blanking on. And he's a very good lawyer, and I think he may be able to work this situation out for you. Okay, ma'am? All right, you're free to go back. Miss Lowry. Miss Lowry, ma'am, you're charged with 1 count of simple battery. Bond is going to be set at $4,000. This is a misdemeanor offense. There's going to be a stay away provision on this bond to stay away from a Keisha Miles. Do you understand that, ma'am? Yes. Your preliminary hearing date is going to be set for December 13th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me? Okay, ma'am, you're free to go back. Ms. Miller? Ms. Miller, ma'am, you're charged with 1 count of battery. This is a misdemeanor offense. Bond is going to be set at $5,000. There's going to be a stay away provision on this bond to stay away from a Sarah Tipton. Do you understand that, ma'am? Your preliminary hearing date is going to be set for December 13th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
I don't have one. Can I tell you something? I live in the same house with Sarah Tipton because it's a safe group home. And I don't have no other home because if I'm homeless, I would be homeless because it's a safe group home. And that's the only place I have to go because I live in the same home with her because it's a safe group home. But
so is there
and if I don't have any home to go in, I'm far away from home. I actually live in Jasper. My mom lives in Jasper. My dad lives in Canton. I've been homeless. That's how I found this place, Mr. Campbell.
Mhm.
I've been homeless for a while, but me and Sarah live at the same safe group home. And we
So,
just-
and this is where things get complicated really quickly, because from a law perspective, criminal law perspective, she's the alleged victim, you're the alleged suspect. And we place stay away provisions on you because you're the person that's before us, because we don't want whatever happened yesterday to flare back up again. And these are misdemeanor offenses where most likely you're going to be able to post bond and get out. So these conditions can be changed later. But it takes, essentially, the alleged victim has to notify the solicitor's office that they would like the condition to be modified, if that is what they want. Now, even if they make that request, it doesn't mean that it's going to happen, because the solicitor's office does its own independent investigation, and they make their own determination as to whether they believe this request is in the best interest of either party.
I'll be homeless, so if when I get bonded, I'll be homeless. I don't live in the state. I want to stay away from her, but I don't have nowhere to go. I'm far away, and I don't have no way to it, and we don't really get along. So,
well, and that's
not that we don't get along. I just want to stay there.
No, and ma'am, I don't want you to hear what I'm saying as being unsympathetic to your position. However, based upon the allegations, my hands are really tied.
Okay, I understand.
Okay.
I
So
just
it
wanted to see if I could have a home, if I could go back there because we live in the same home. But I mean, I don't know where I'm going to go. That's all.
It may be in your best interest to go back to either a family member's home. And I know that may not be ideal, but I definitely can't allow you back into that space at this point without there being an investigation. Okay. So I'm going to appoint a lawyer to represent you, ma'am. And I wish you luck, and I wish I could do more for you. But that's all that I can do at this point.
Okay.
All right, ma'am, you're free to go back.
Thank you.
You're welcome. Miss Knowles.
Hello.
Hello, ma'am. You're charged with 4 misdemeanor driving related offenses. The first is driving under the influence. Bond is going to be set at $5,000. The second charge is improper lane change. Bond is going to be set at $500. The third charge is improper stopping. Bond is going to be set at $500. And then finally, you're charged with driving on the wrong side of the road. Bond is also going to be set at $500. Because these are all misdemeanor offenses, your preliminary hearing date is going to be set for December 13th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes. All right, so I'm being charged of driving under the influence when the test, every test they gave me, I passed. So I'm a little confused with that.
Okay.
And I was up all night packing to move because I was getting evicted, and I took my kids to school, get there, realize I'm too tired to drive home. So I sleep in the parking lot for like 4 hours. I leave, when I wake up, go home 10 minutes from the house, something got in my eye. I started rubbing it. I do admit that I did swerve, and then the guy pulled me over and was saying I was doing all kind of stuff, which I wasn't, because I wasn't even going up 30 miles an hour. So I'm a little confused with, all of that. I do have medications that I take, but the last time I took it was like, it was 2, 3 that morning. And this time with this officer that pulled me over, it was like 12:30 in the afternoon. My
Okay.
medication, it says it lasts from 8 to 10 hours. He's telling me 18 hours. So I'm just a little confused at how he came to all of that.
Okay, ma'am. Well, based upon what he put in the warrant that's before me, it says during the horizontal gaze nystagmus test that he observed 4 out of 6 clues in both of your eyes. During the walk and turn test, he observed 4 out of 8 clues. During the one leg stand, he observed 2 out of 4 clues. And so this doesn't mean that you're guilty of driving under the influence. These are the indicators that the officer said he observed that made him believe that you were driving under the influence. That's why we appoint lawyers as quickly as possible so that your lawyer can go through this. I'm sure there's a video. I'm sure there's a lot. So that if this is a situation where you are innocent, meaning they can't prove your guilt beyond a reasonable doubt, then the information is here for your lawyer to be able to attack it. Okay. All right, ma'am. Is there anything else?
No.
Okay, ma'am, you're free to go back. Miss Rushing Gillespie. Ma'am, you're charged with 1 count of criminal trespass, damage to property. They charge it as a misdemeanor. Bond is going to be set at $5,000. You also charged with 1 count of disorderly conduct, charged as a misdemeanor. Bond is going to be set at $1,500. There's going to be a stay away provision on this bond, to stay away from a Roshonda Qualls. Do you understand that?
Yes, sir. I don't even know her, but yes, sir.
Okay. Your preliminary hearing date is going to be set for December 13th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir, please.
Are you currently working?
No, I play basketball in school.
Okay. I'm going to find that you do qualify. I'm going to appoint a lawyer to represent you. And just so you know, ma'am, the person that is in here, this is the person, allegation is that you used the handgun to break out the front passenger side window and then fired a handgun twice. So that's the allegation. So whomever that person that owned the vehicle, that's the person that's being listed as the alleged victim. Okay.
Yeah, I don't even know her, but
Okay.
you said her name's what?
Roshonda Qualls. Qualls.
Yes, sir.
Okay, ma'am, you're free to go back. Miss Weber. Miss Weber, ma'am, you're charged with 1 count of battery. This is a misdemeanor offense. Bond is going to be set at $5,000. You're also charged with 1 count of cruelty to children in the 3rd degree. This is also a misdemeanor offense. Bond is going to be set at $3,000. There's going to be a stay away provision on this bond, to stay away from a Tia Garlington. Do you understand that, ma'am?
Yes, sir.
Your preliminary hearing date is going to be set for December 13th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? I'm sorry.
Yes, sir.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Well, after today, like when I bond out, I'm going back to my hometown. I'm no longer going to be around them people. They was my husband, family. Long story, but I was wondering, well, I might gotta come back here anyway. It's crazy. It's okay.
Ma'am, you can ask me whatever question you want to ask as long as it's not about the facts of your case.
No, about what?
The facts of your case.
Oh, no, sir. I was just gonna ask, could I transfer it to LaGrange? Because I'm not gonna have a car, but I about figured that was just stupid because it happened down here.
Okay, so ma'am, I'm not putting any conditions on your travel. I'm just putting one condition for you to stay away from Tia Garlington. So if you need to travel back to where you're from, that's fine. You just need to appear for any court dates. You need to make certain that the sheriff's department and the clerk of state court has your current address for you to receive mail, wherever that may be. Because if you miss your court date, there's going to be a bond issued, a warrant issued for your arrest.
No,
Okay.
I wasn't saying I was fleeing. I was just saying, like, could my court matters be handled in LaGrange court?
No.
But yeah,
No.
that's what I was saying all in one, asking at the same time. Yeah.
Okay. All right. Well, you're free to go back, ma'am. Let's bring up Miss Winn and Mr. Baker on the men's side.
How you doing?
I'm doing well. I'm waiting on Mr. Baker so I can speak to the two of you at the same time. Mr. Baker. Okay, Miss Winn and Mr. Baker. The two of you still have all of the rights and privileges as I discussed earlier, but the two of you are here on something a little different, and the legal term is fugitive from justice. And what that basically means is that there's a warrant for your arrest out of another state, and that state has indicated that they want to extradite you, meaning bring you back to their state to face those charges. As it relates to Miss Winn, ma'am, there's an allegation that there's a warrant for your arrest out of Orange County Sheriff's Department for failure to appear on an aggravated assault charge. And they indicated that it is their intent to extradite you, again, meaning to bring you back. Mr. Baker, in your case, there's an allegation that there's a warrant for your arrest out of the New Orleans Police Department for animal cruelty. And they have also indicated that they intend to extradite you or bring you back. Now, what I'm about to say applies to both of you. This whole process is one where the state of, or the county of Clayton and the state of Georgia has no interest in your guilt or innocence. We cannot try this case. We cannot make any determinations as it relates to this case. All we're here to do is to hold you because Florida and Louisiana said that they want us to hold you so they can come and get you. If you believe that you are the person named in the warrant and you believe that these charges are legitimate, you can waive the process of having them to go through a determination of if you are the person named in the warrant and if the charges are valid. If you were to waive it today, and for Ms. Winn and Mr. Baker, after I finish talking, I'm going to shut up and I'm going to let y'all talk. So we don't have to have a back and forth. Okay. So if you were to waive that hearing today, each jurisdiction will have 30 days to come and get you. They request an additional 30 days, and that request may or may not be granted. If they do not come and get you within the statutory time period, the Clayton County will release you out the front door. but it does not mean that that warrant goes away. So you can be released out of the front door. You interact with another law enforcement officer 5 minutes after being released. They run your information, see that there's a valid warrant. You get taken into custody, and this process starts all over again. If you believe you're not the person named in the warrant, or if you believe that the charges are not valid, or if you just want a hearing, you can request a hearing today. If you do that sometime between now and the next 90 days, a hearing will be held to determine whether you are the person named in the warrant and whether those charges are valid. At the end of that hearing, if the judge believes that those two conditions have been met, the judge will then sign off on the extradition, and Florida and Louisiana will be notified. And then that 30 to 60 day window that I discussed earlier will begin to run at that time. So I'm going to ask for Ms. Winn to be unmuted, and I'm going to ask her if she's still with me. Are you still with me, ma'am?
I hear you.
Okay. Mr. Baker, are you still with me, sir?
Yes, sir.
Ms. Winn, do you have any questions about anything that I said?
Yeah, what, I'm gonna ask y'all what day, cause this happened, because they came from another state and they got me and took me to Florida when I did my time. And they said this happened like 2011 for assault and battery. I don't know what is y'all talking about, because all my charges that I did are for assault and battery and one self-defense. So I don't know what y'all talking about. Man, my sister said she will tell y'all that they came and got me from Riverdale Road, 5503 Riverdale Road, apartment 5C. So I really don't know what y'all talking about aggravated battery. I never did that. They all assault and battery, one self-defense.
Okay. Do you have something to write with, Ms. Winn?
Yes, sir.
I'm going to give you the warrant number. Are you ready?
Oh, sorry about that. Okay.
The warrant number is W906
Uh-huh.
915
Uh-huh.
896.
Okay.
So as I indicated earlier, Clayton County in the state of Georgia has no interest in this. This is a warrant that popped up under your name. They contacted Orange County Sheriff's Office and they said, yes, this warrant is valid. Hold her. We want to extradite her. So based upon what you just told me, sounds like you need to get a lawyer in Orange County. You have the warrant number.
Yeah.
And then look into this, and it could be wrong. Or you could have additional charges that you didn't know anything about.
Exactly.
But because Clayton County, we didn't, as you say, you don't know what y'all are talking about. We didn't do this. This is coming out of Orange County. So if you want to get to the bottom of it, that would be the route to go.
So I asked you, I can leave today, or I gotta stay here today, like stay for another 30 days.
So ma'am, you're gonna stay here based upon the procedure that I laid out in the beginning.
If they don't come, I'm free to go, right?
Yes. Now, I'll tell you this, ma'am. It says a failure to appear, and especially during this time of the pandemic, what I've seen, especially on failure to appear, if someone takes a step of hiring a lawyer and that lawyer contacts in Florida and that lawyer goes down there, says, hey, my client, whatever, my client didn't know anything about this. My client, they hired me as soon as they found out. I'm here to look into this. You don't have to worry about it. My client will be back. Now, at that point, Orange County has to decide, do we want to spend the money to come up there and get this person? Or are we comfortable with the representations of the lawyer, putting this case back on a calendar, and then the person shows up? And I've had situations where a person appeared before me on Wednesday. They hired a lawyer, they did what they were supposed to do. That person came back on Friday with an order from the other jurisdiction saying release them.
Okay,
So that's what I'm saying. They say hold, we hold. They say release, we release.
but I have to stay here now.
Yes, ma'am.
So y'all gonna call today and see if they gonna come get me or what?
Well, ma'am, if you say today that you want to waive that hearing, the fugitive office will contact Orange County Sheriff's Department today.
I want them to
And-
contact 2 days and
Hold
see if they gonna come.
Miss Wynn, you're violating the rules, remember? One person talks, the other person listens. So you ask, I'm gonna give you the information, and then I'm gonna listen to any other questions you may have, okay? So because I am not in contact with Orange County Sheriff's Department, I don't know that timetable. The fugitive office, they're in contact with their colleagues on the other end. I've had situations where detectives were waiting outside for when the court was over. They took the person right then and there, got on a plane and flew back to New York. Depending on the choice that you make here today, that determines what happens in the future. So if you were to say, hey, I want to waive this, they will contact the Orange County Sheriff's Department today, and then a plan will be put in place to come and get you. Now, you may want to do both if that's something that you want to consider, waiving the hearing and hiring a lawyer to work both ends down there so that they know that you have a lawyer. They know that they may not have to spend the money to come get you. And they may decide to, yeah, let's just release her. That's easier. But I don't make those decisions. They make those decisions. But you have to take affirmative steps to protect yourself, either way it goes.
All right.
So do you know what you want to do?
Yeah, I'm just getting a lawyer. And like you said, waive it, see what both of them say, you know. I know that right now they gonna drop it. Because I know they gonna drop it.
Okay, well, once you sign the waiver, they'll send it to me and I'll sign it, and that clock begins to run today. I gave you the warrant number, so at least I know you said you're in contact with your sister. Share that information with your sister, and maybe, you know, this is something that it's a mistake.
But hold on, sir. You said, do I want to waive it or not?
I thought I heard you say you wanted to waive.
No, I don't want to waive it. I just want to get my lawyer. I got a lawyer. My
Okay.
sister's a lawyer.
Okay, so sometime between now and the next 90 days, there'll be a hearing set on this issue. Okay, ma'am?
All right.
All right, you're free to go. So for the record, you do not want to waive.
All right.
Thank
Yeah.
you.
All right.
Mr. Baker,
Yes, sir.
now, let me first ask, do you have any questions? You've heard everything, the discussion I had with Ms. Wynn.
Yes, sir. I would like to waive.
Okay, once you sign the waiver, sir, they will send it over to me. I'll sign it, and then that window begins to run today. But also, you should do the same thing. Try to hire you a lawyer down in Louisiana.
Yes, sir.
Okay. All right. Once he signs the waiver, he's free to go back.
All right. That's all right.
All right, that's all the females.
Thank you, sir. Have a good day. Have a good weekend.
All right. I'll send you over.
Okay, let's bring up Mr. Batty, B-A-D-I-E. Sir, you're charged with one count of a window tint violation. Bond is going to be set at $500. You're charged with one count of felony possession of marijuana. I'm going to deny bond on that charge now. Based upon it looks like you were arrested earlier this year in Crisp County. I think it was March of 2022. And you're charged with one count of use or possession of drug-related objects. That's a misdemeanor. Bond is going to be set at $1,500. You're going to have a preliminary hearing date set for December 14th at 8:30 in the morning. You're going to also have a bond hearing date set for December 16th at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. I'm going to find that you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Me being stopped by the window tint, did they like test the percentage of my window tint to be illegal?
Well, they did say that they tested it. Give me 1 second. It said it only let in 9%. And it said that there's the legal percentage is 32%. Now, I've appointed a lawyer to represent you, and you may want to have a conversation with the lawyer because your car was from Florida, correct?
Yes, sir.
So I don't know what's legal or illegal in Florida, but your vehicle is supposed to be legal for wherever you live. So if that's legal in Florida, it will be legal in Georgia.
Okay.
All right. Any other questions?
No, sir.
Okay, you're free to go back. Mr. Brown. Mr. Brown, sir, you're charged with one count of driving under the influence of alcohol. Bond is going to be set at $5,000. You're also charged with one count of impeding traffic. Bond is going to be set at $500. These are both misdemeanor offenses. So your preliminary hearing date is going to be set for December 13th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? I'm going to find that you qualify, Mr. Brown. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
No, sir.
Okay, you're free to go back. Mr. Collins. Mr. Collins, sir, you're charged with one count of family violence battery. Bond is going to be set at $5,000. There's going to be a stay away provision on the bond to stay away from a Javaris Collins. Do you understand that, sir?
Yes, sir.
Your preliminary hearing date is going to be set for December 13th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Collins. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back, Mr. Collins. Mr. Daniels. Mr. Daniels, sir, you're charged with one count of violation of Georgia Controlled Substance Act. And this is a felony offense. And there's an indication that you're on probation or parole. So I cannot set bond for this offense at this stage. So bond is going to be denied pursuant to Georgia statute 17-10-1. You're going to have you're also charged with misdemeanor obstruction. I'm setting a bond at $2,000 for that offense. You're going to have a preliminary hearing date set for December 14th at 8:30 in the morning. You're going to also have a bond hearing date set for December 16th at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
No, sir.
Okay, I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back, Mr. Daniels. Mr. Davenport.
Yes, sir. Good morning, Your Honor.
Good morning, Mr. Davenport. Sir, you're charged with 1 count of misdemeanor shoplifting. Bond is set by schedule, which means it's automatically set at $2,000. You're going to have a preliminary hearing date set for December 13th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. It says you refuse to fill out the form. Does that mean you're going to hire your own lawyer?
I already had an attorney for this and I already made bond.
Okay. All right, sir. Then you are free to go back.
Thank you, sir.
Okay. Mr. Folk.
Yes, sir.
Mr. Folk, sir, you're charged with, let's see, 1 misdemeanor offense and 3 felony offenses. You're charged with possession of marijuana less than an ounce. That's a misdemeanor. Bond is set at $1,500. You're charged with possession of a firearm by a convicted felon, and this is an offense I can't set bond for at this stage pursuant to Georgia Statute 17-10-1. You're also charged with a felony offense of possession with intent to distribute marijuana. I also can't set bond at this stage pursuant to Georgia Statute 17-10-1. And you're also charged with possession of a firearm during the commission of a felony. I guess felony offense. I can't set bond pursuant to Georgia Statute 17-10-1. Your preliminary hearing date is going to be set for December 14th at 8:30 in the morning. You're going to have a bond hearing date set for December 16th at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, I'm going to find that you qualify. Sir, I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, I do. Can you tell me what the 3 felonies was again?
Possession of a firearm by a convicted felon, possession of marijuana with intent to distribute, possession of a firearm during the commission of a felony.
I'm trying to figure out how I got the intent to distribute charge.
Well, it says that this was what they characterize as a marijuana transaction on Old Dixie Road in Forest Park, where the allegation is that you sold 3.5 grams of marijuana for approximately $45.
Okay, this is my thing though. When they just looked it up, it said it had to be over a certain amount of marijuana for it to be an intent to distribute. If I had less than an ounce, I don't understand how they're trying to give me an intent to distribute.
Okay. I don't understand that. I really don't. Intent to distribute is essentially selling. And so if they say the allegation is that they say you sold marijuana. Now, again, this is being recorded. I don't want you to get deep into the facts of your case, but if you have a question for me. So let's say I have an ounce of marijuana, which is a misdemeanor amount of marijuana, and I cut it up into smaller amounts of marijuana. It still equals less than an ounce, but I'm selling each one. I am intending to distribute it. It's not, hold on. It's not that I have an ounce of marijuana and I bought it in this ounce because I know that's less than a felony amount, and it allows me to smoke it when I want to. Right? That's possession. All right. If I start selling it, that's intent to distribute. Okay.
Yeah, I understand. Were you finished? I didn't mean to interrupt you. I understand
Oh,
everything, sir.
Yeah, go ahead. Go ahead. I'm sorry.
I understand what you're saying, sir, but it's just like you said, like if I separated it with the intent to sell marijuana, then that would be basically what the charge is. I didn't have anything separate, none of that. I had marijuana, I was smoking. Nothing was separated, nothing.
So Mr. Falk, again, and this is why I don't like getting into these conversations, because you've admitted now to having marijuana on you, and the only question is whether it was an intent to sell or not. And let's assume that you are operating under an erroneous assumption about whether the facts are intent to distribute or not. You've now gotten yourself way down the road to a conviction. And if you are wrong, you've admitted essentially to a felony offense. That's why we appoint lawyers, so you can talk to the lawyer and try to work it out.
And my last question is, does it, like, how come you said you couldn't set a bond? Like, I'm not on probation, parole, nothing.
All right, hold on. All right. So when I look at your criminal history, Mr. Folk, this is your 29th cycle.
My who?
Cycle. Every time you have an interaction with law enforcement, they call it a cycle.
Okay.
All right. So let's see.
I don't mean to interrupt you, nothing, sir, but my entire record is majority no license. So I understand you're saying it's the 29th cycle, but out of those 29, probably 23 are no license.
Okay.
I don't have a violent background. I'm not a like compulsive felon, nothing like that.
And I'm not saying that you have a violent background. You keep having these probation violations.
I haven't been on probation in years, sir.
Okay.
Like I said, I'm not even on probation or parole now. I haven't been on probation in the last 3-4 years.
All right. So what I'm seeing is the last probation violation was January 3rd of 2020. Well, no, it was January 8th of 2020 in Clayton County.
That's false.
Then let's see. You got arrested earlier this year, Peachtree City, for
I'm in charge. I'm going to trial for that in Fayette County now.
For possession of firearm by a convicted felon and theft by shoplifting. Okay. Then arrested. Nope. Same thing. Says Fayetteville Police Department. And it also says February 9th of 2020.
February 9th. Yeah, correct. February 9th. Yeah. I don't know about the January thing though, because I wasn't incarcerated in January of 2020.
So it's showing probation. And I don't know, sometimes when people are on non-reporting probation, they don't necessarily believe they're still on probation, but they are, or if they received a suspended sentence. The thing that will carry today is if you have your discharge. If you have the discharge, the documents that say he's no longer on probation, he's done. You get those from the probation officer. You have that, show it to your lawyer. This will all potentially change. Because I'm telling you, sir, with your criminal history, there's a judge has to think about public safety, and it doesn't appear that you care much about public safety with all of these arrests.
But if my arrest, I understand what you're saying, sir, but if my arrest, like I said, is no license, all of those arrests are no license, how does it seem like I doesn't care for public safety? But I'm not trying to make it seem like you don't know what you're saying or doing nothing. I'm just trying to get an understanding. Like I was saying, like I originally just wanted to understand why I couldn't get a bond set, because I'm not, you said if you're on probation or parole and thing, I'm not on none of those.
Well, that's what is showing on your criminal history.
That I'm on probation?
Yes.
How could it be showing that? I haven't been on probation.
I don't sit at the computer and put this information in. So you ask me how. Wait, please. I'm trying to tell you how to get to the bottom of this. Okay. So as a judge, if I see this and it appears that you're on probation, my job is to deny bond on felony offenses. My job is not to say, you know what? Let me call up the GCIC and the GBI. Let me call up the Fayette County and ask, is this man still on probation? No, sir. My job is to answer the questions you have. You know what the allegation is against you. You know how now to defend yourself and deal with it. Because if you're right, all you got to do is get the information and all of this goes away.
You get in touch with, you get the information, like do it say where the probation is from?
Okay. Give me 1 second. It should be out of the Georgia Department of Community Supervision.
Dude, where would that even be? I don't even know what that is.
Well, I know they have an office downtown across from the City of Atlanta jail.
Okay.
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 All right, sir. You're free to go back.
And it says I go back to court on the 14th and the 16th?
Yes, sir. But if what you're saying is true, this can all get changed before then. Okay. And the reason I tell you this stuff so that when you speak to the lawyer, that's the first thing you should tell the lawyer. Judge says I'm on probation. That's why he denied bond. I'm not on probation. I can prove it. And the lawyer has something to work with.
So you're waiting for the lawyer to come see me and have my family get everything situated, basically.
I would do both. The lawyer is going to, what I understand is that they set up to try to be as quickly as possible. They set up visits on the little phone thing so that they can speak to you as early as possible. They can get information from you. And I encourage you to tell the lawyer what I just told you. Okay. All right. You're free to go back. Mr. Goins.
Sir.
Mr. Goins, sir, you're charged with 1 count of family violence battery. This is a misdemeanor offense. Bond is going to be set at $5,000. There's going to be a stay away provision on the bond to stay away from a Simone Webster. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for December 13th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Because it's my first time being locked up. You say $5,000?
Yes, sir. Any other questions?
Yeah. So it's gonna be like 500.
Yes, sir. Roughly that amount.
All right. All right. So I can't leave today.
You will if you can post your bond today. You will leave today.
All right. Okay.
Okay. All right,
All
sir.
right.
You're free to go.
Thank you, sir.
You're welcome, Mr. Haywood. Mr. Haywood, how are you doing, sir?
Not too good, I'm in jail.
I understand. It appears that detectives came yesterday and got additional warrants from Judge Duvernay. So you have 4 additional felony charges.
Huh?
Yes, sir. One is aggravated assault with a deadly weapon being a vehicle.
What?
And I'll explain it to you, sir. The next is impersonating an officer,
Huh?
robbery, and entering an automobile. So bond is going to be denied on all of these. This gives a little bit more information than what I had on Wednesday. So the allegation, sir, basically is that you went into a pawn shop, and that according to the lady behind the desk, she thought you came in a couple, maybe 4 or 5 times. You requested to see a gun. She requested your identification, and based upon what she said, you alleged that you were an undercover police officer working with the GBI. Sir, I'm just telling you what's here, okay? I didn't write it. I didn't swear on a book of Bibles that this is true. I'm just letting you know so you can tell your lawyer. I made sure all of this stuff is placed together. And so you'll have same lawyer, same set of facts. Everything is before that person. So you're not being piecemealed out, okay? The robbery charge, the allegation is that you went into the back seat of this lady's car who worked there, and she saw you taking things out of the back seat of the car, that you and her engaged in an argument, that you got in your car and tried to drive away, and she apparently jumped on your hood of your car as you were driving off. So that's the aggravated assault, that's the impersonating an officer, that's the robbery, that's the entering an automobile. So those are the basic allegations, okay? You're going to have the same preliminary hearing date. I'm going to make a notation.
So what about the other charges that are those still standing, or are those being dropped or processed, or what's going on with the other 4 charges?
Well, currently they're still standing, but that's a discussion that you should. Yes, but that's a discussion you should have with your lawyer, because some of this stuff may end up merging together or being part of the same thing. But that's a discussion that you have to have with your lawyer.
Okay.
All right. Okay. So you're going to have December 14th and December 16th for these charges. And you're free to go back.
All right. Thank you.
You're welcome. Mr. Jackson. Mr. Jackson, sir, you're charged with 1 count of misdemeanor theft by shoplifting. Bond is set at $2,000. You're going to have a preliminary hearing date set for December 13th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, sir. Going to appoint a lawyer to represent you. Do you have any questions of me? Okay, sir, you're free to go back. Mr. Jenkins.
Yes, sir.
Mr. Jenkins, sir, you're charged with 1 count of felony obstruction of a law enforcement officer. It also appears that you're on probation or parole. So I cannot set bond for this offense pursuant to Georgia statute 17-10-1. You're going to have the preliminary hearing date set for December 14th at 8:30. in the morning. You're going to also have a bond hearing date set for December 17th at 8:30 in the morning. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, Mr. Jenkins. I'm going to appoint a lawyer to represent you. Now, do you have any questions for me?
Yes, sir. What makes it felony obstruction?
So misdemeanor obstruction is interfering with an investigation, a police officer in the lawful discharge of their duties. A felony obstruction is when you offer harm to that officer, and the officer is alleging that you offered harm or became aggressive with the with the law enforcement officer when he was questioning you about giving a false name. And so it's something that you should discuss with your lawyer. But right now, because there's an indication that you're on probation or parole, I can't set bond on this.
I understand. I know what's going.
Okay. All right, sir. You're free to go back. Mr. Michaels. Mr. Michaels, sir, you're charged with three misdemeanor offenses and one felony offense. Charged with one count of being under the influence of a substance, and it says combined substances. To the extent that you're a less safe driver, bond is going to be set at $5,000. Charged with one count of possession of marijuana less than an ounce, that's a misdemeanor offense. Bond is going to be set at $1,500. One count of use or possession of drug-related objects, that's also a misdemeanor offense. Bond is going to be set at $1,500. And finally, one count of felony, simple possession of methamphetamine. Bond is going to be set at $3,000. Because of the felony offense, there's going to be a preliminary hearing date set for December 14th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, sir, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Describe the bond option for me.
Okay, so you have three options. The first is to pay the entire amount of the bond in cash to the sheriff's department. They will hold that money, and when your case is resolved, they would return that money to you. Second option is to go through a bonding company. The bonding company will charge you a fee, generally somewhere between 10 and 12% of the total bond amount. That fee is what they charge for the service of posting your bond. That fee will not be returned to you. Finally, you can use property. If you have property in Clayton County that has an equity, at least a net equity, at least 3 times the bond amount, you can use that property as collateral. The sheriff's department will place a lien on that property, and when your case is over, they will remove the lien from your property. Those are your options. Anything else, sir? Okay, you're free to go back, Mr. Michaels.
I said that I'd like to speak with an attorney, right?
Yes, I've appointed an attorney to represent you.
Thank you.
You're welcome. Mr. Rodriguez. Sir, you're charged with 1 count of trafficking marijuana. This is one of those offenses that I cannot set bond. The allegation is that the total weight of the marijuana is over 10 pounds. And I can't set bond on anything over 10 pounds. So bond is going to be denied pursuant to Georgia statute OCGA 17-6-1. You're going to have a preliminary hearing date set for December 14th at 8:30 in the morning. You're going to have a preliminary hearing date set for December 14th. And I may have confused myself, so I was writing down the bond hearing date. Your preliminary hearing date is going to be set for December 14th at 8:30 in the morning. Your bond hearing date is going to be set for December 16th at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
I believe I already have.
Okay. All right, sir. Do you have any questions for me? Okay, you're free to go back, Mr. Rodriguez. Mr. Russ.
Areas in the Russ area.
We don't have Cortez Shamar Russ.
You said what now?
Last name Russ, R-U-S-S. First name Cortez, C-O-R-T-A-Z-Z. Middle name Shamar, S-H-A-M-A-R.
I'm sorry, he got
Okay. I'm gonna do a reset notice or continuance notice for him to be brought back tomorrow. He's here on a CW, and so he has 72 hours, and he's facing some serious charges. Let's bring up Mr. Talley. Are you Mr. Talley?
I'm gonna tell you about Russ.
You remember Russ? He's in probation court.
Ah, you did tell me that. Thank you. I'm gonna do a continuance for him.
All right.
Mr. Talley.
Yes, sir.
Sir, you're charged with 1 count of family violence battery. That's a misdemeanor offense. Bond is going to be set at $5,000. You're also charged with 1 count of cruelty to children in the 3rd degree. That's also a misdemeanor offense. Bond is going to be set at $3,000. There's going to be a stay away provision on this bond, a stay away from a Jessica Rogers. Do you understand that?
Sir, if I is there any way that I could bring the defendant to get everything solidified, because
hold on, Mr. Talley. Right now, I want to see if you understand that there's a stay away provision.
Yes, sir. Yeah, I understand.
So, and as you probably noticed, I end everything with, do you have any questions?
Okay, all right.
But there are things I have to tell you. And generally, if we start going back and forth, one person forgets one thing or another. You're going to have a preliminary hearing date set for December 13th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, sir. No, sir.
Okay. You're going to represent yourself?
Well, I have a lawyer. I have a lawyer already. I have to get to that.
Okay. Now, do you have any questions? What was your question?
If I could bring the defendant to, I don't know, like where do I have to bring is there any way that I can bring the defendant up here to squash everything? Because she didn't go through with it. Like, she didn't go through with it. You know what I mean, with the whole thing or whatever. Like, but I guess the state picked it up.
Yeah.
That's my child. That's my child. we got a newborn, we got a 3-year-old together. You know what I mean? Like, so
Okay.
and everything was really a misunderstanding. Like, but is there any way that I can go about this?
Let me, and because I get asked this question all the time. So I understand what it is, what the question you're trying to ask. So this case came to the state's attention. And the officer decided to go get warrants for your arrest based upon whatever was told to the officer. Okay. Based upon that, these warrants were generated, and now you're here. It's not as simple as I was mad and now I don't want to go forward with it. Okay. So right now, and you were referring to Ms. Rogers as the defendant. She's the alleged victim in this case. You're the
victim, huh?
yeah. It's she's the alleged victim. You're the alleged defendant. Okay. Now, she can say whatever she wants to say to the solicitor's office. They will do their own independent investigation and make a determination as to how they wish to proceed. It's not as simple as now she decides she doesn't want to pursue charges, but at some point she did. And what I especially younger people, I have to say, look, when you invite a third party into your life, that third party gets to have a say. So it's not just you and Miss Rogers anymore. It's you, Miss Rogers, and the state. So way for these things not to happen is for people to not get into disputes to the extent that it becomes physical. And then nobody goes about jumping into your business. So the short answer to your question is that there can be a request made, but it's going to be up to the Solicitor General's office how they wish to proceed. Okay. Anything else? Okay. All right, sir. You're free to go back. Mr. Taylor. Mr. Taylor, sir, you're charged with 1 count of criminal damage to property in the 2nd degree. This is being listed as a felony offense. There's going to be a bond set at $4,000. There's also going to be a stay away provision on this bond. Stay away from a Destiny Arnold. Do you understand that?
Yes, sir, I do.
Oh, have you been paying attention?
Yeah, yes, sir, yes, sir. Yes, sir.
Okay.
I'm just getting real eager to ask these.
Your preliminary hearing date is going to be set for December 14th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Sir.
You do qualify, Mr. Taylor. I'm going to appoint a lawyer to represent you. Now, sir, tell me whatever it is you want to tell me.
Okay, so it's kind of like the last person my baby mother. We stay together. We pay, like, I pay rent in that apartment. You know, we have a child together. It was really just an argument. I was trying to leave, sir. Like, you can tell, I have bruises. I have bruises and marks on me. I was trying to leave and de-escalate the situation, sir.
I understand. So
if it,
I'm gonna,
because it's like if I have to stay away from her, so I won't have anywhere else to live, sir. And I just paid 4 months of front of rent until February, so I won't have anywhere to live, sir. I don't have any family down here.
Mr. Taylor.
Yes, sir.
This stay away provision is going to stay in place. And I'll explain it to you in 2 ways. Okay. If you were my son, I would say to you, son, do you really want to stay in a house where, according to what you're telling me, this was something minor that got blown up and cause for you to be arrested? Do you really believe that that's the best life that you want to live, where you're on pins and needles every day, wondering if this person is going to call the police on me and I'm going to go back to jail? Okay, that's option number one. Option number two, the allegation that Miss Arnold made is true. Stop. The allegation that Miss Arnold made is true, and you're with someone that it gets so upset that you get so upset that you break her phone. Again, is that the type of house or environment that you think is in your best interest?
No, sir, but like it's like I didn't even get a chance to write a statement or give my side of the story when I was arrested, sir. She had my phone, like I was trying to leave, sir. She had my phone, and when I tried to grab my phone from her, she would yell, help. So I could not touch her, sir. So I grabbed her phone. I was going to use her phone to call somebody.
See, you're getting into the facts of the case.
Okay, but still.
I've appointed a lawyer
Sir, I understand.
that you can tell all of this stuff to, and the lawyer, based upon what you're telling me, it should be easy for the lawyer to get this case dismissed. Okay?
Sir, I just had a
the living conditions. So, Mr. Taylor, and I want you to pay attention to me, sir. There are a lot of people who are sitting in jail now for the rest of their life because an argument went too far. They love the person. They never intended to hurt that person, but they got into an argument, pushed the person fell down, hit their head, and died. Can't bring that person's life back, and can't stop you from having your life taken away, where you spend the rest of your life in prison. So the recognition is that if there are two adults that are living their life to the extent that law enforcement has to be called out, that they are not in a position to control themselves, at least not now. And maybe they need to go through counseling, maybe they need to go through whatever. But it's not that you can't ever be together, but Clayton County is not going to be coming out to your house every day when there's a dispute.
This is the first time this has ever happened. Like, this is my first time ever like coming out here to, and like her phone was broken. She broke my TV that's worth more than her phone, sir. So it's like I don't understand. I have a daughter that stays with me. Like I provide for my family, sir.
I understand, Mr. Taylor. Have this discussion with your lawyer and really and truly think about whether this relationship is the best for you. All right, you're free to go back, Mr. Taylor. Mr. Weems. Mr. Weems, sir, you're charged with one count of simple battery, family violence. Bond is going to be set at $4,000. You're charged with one count of false imprisonment as a felony. Bond is going to be set at $5,000. There's going to be a stay away provision on this bond to stay away from a Jessica Burnett. Do you understand that?
Yes, sir. You said what the second was? My bad. You said what the second was?
False imprisonment.
What's that?
Allegation is that you sat on top of Miss Burnett and restricted her movement as she was telling you to get off of her.
No, I had grabbed it and kissed her.
I don't. Talk to your lawyer. This is being recorded. I don't know how many times I got to keep. All the prosecutor I do is press a button. And I will let you speak. But I'm going to tell you, there's nothing that you can tell me that's going to change my mind about what I've done here because what I've done here takes into account the fact that you're presumed innocent and that you have a right to a lawyer to represent you, and that you should be speaking to that lawyer about what happened so that that lawyer can defend you. So you can tell me it happened or it didn't happen. I don't want you to tell me how it happened. As far as the law is concerned, this is an allegation against you that the state has to prove beyond a reasonable doubt. Okay. Now, your preliminary hearing date is set for December 14th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer? You do qualify, sir. I'm going to appoint a lawyer to represent you. Now, you can tell me whatever you want to tell me, but keep in mind this is being recorded.
And I like by myself out. I got the money.
Okay, I didn't understand that.
Can I buy myself out? I got the money. Like,
Yes, sir. Yes, sir. Just have that discussion with the personnel at the sheriff's department, and they will direct you as to what you need to do. Okay?
Yes, sir.
All right, sir. Free to go back. Mr. Wooten.
Yes, sir.
Mr. Wooten, sir, you're charged with one count of simple battery as a misdemeanor. Bond is going to be set at $4,000. One count of simple assault as a misdemeanor. Bond is going to be set at $3,000. And one count of terrorist threats or acts as a misdemeanor. Bond is going to be set at $3,000. Because these are all misdemeanors, you're going to have a preliminary hearing date set for December 13th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. I don't see a form. Hold up. Sorry, Mr. Wooten. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir. That's fine, sir. Yes, sir. Thank you.
Okay, I'm going to find that you qualify, Mr. Wooten. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yeah, you said I'm just trying to figure out the total amount of the bond was like 9,000. Is that correct?
It's, let's see, I think it's 10,000.
Is it 10,000?
Yes, sir.
The reason I'm asking y'all is because I know you're not going to change nothing as we talk, but it's just I don't understand how they can come to my house. I'm not, about my vehicle being missing, and then I get locked up. I don't understand that.
So the allegation is that while they were talking to you, that you became upset. And the allegation is that your stepdaughter was trying to calm you down, Miss Smith, and you pushed her with an open hand as she was trying to calm you down. And that's the simple battery.
Okay, I got that, but I never touched her. I just raised my arm up like that for her to mind her business, but I got you.
Okay. And then as it relates to the simple assault, it says that the allegation is you began yelling in the face of the officer, and that you were so close that you were spitting in the officer's face as you were yelling. Not like, hawking.
I got it.
Right.
But I was close. I know I was there.
And that once that you were in custody, that you threatened the officer, saying that you were gonna beat his mother effing A.
That's just alligator. That's just something they want to put on me. But I got you. I understand, sir.
So that's how all of this stuff came about. Now, just have a conversation with your lawyer, because there should be dash cam or body worn cameras, and if this stuff happened, it's on the camera. If it didn't, it's not on the camera.
Okay, that's why I was going to ask you also. My wife was videoing the whole thing with her phone, so I can bring that to court as well. Yes. Okay.
Well, share it. Yes, share it with the lawyer first. Share it with your lawyer first. And let the lawyer know that your wife has that information. And I'm sure that they're going to want to review it.
Okay, so now I got a bond out. So when I go to court and be found not guilty, there's nothing that can be done to the officer for lying.
Well, again, assuming what you said is 100% true, it will be shown on whatever video evidence is there. And that's what you should then have a conversation with your lawyer about. What are the next steps?
Yeah, because like you taking me from my house. I know I've been in trouble in the past 20-something years. You know, you understand what I'm saying? So that's why okay, I got you.
I do. Okay. Anything else, sir?
No, sir. Thank you very much.
Okay. Have a good day.
You too, Your Honor. Thank you.
You're welcome. That should complete